Welcome everyone to our latest webinar from the Glasgow Centre of International Law and Security. First of all, before we start this seminar, let me all draw your attention to the fact that we are recording this seminar. So if you do not want to be seen, please turn your camera off, just to make you aware of that. Also, if you obviously miss anything, you can catch up with it at a later point by downloading this from the website. So with that, let me turn to our guest today. Helen Duffy is joining us today, and let me introduce her to you, those who don't know her. She is a Glasgow girl, if I may say so, Helen. She runs, as a lawyer, the Human Rights in Practice law firm, which specializes in the strategic use of law to protect human rights. She's also a professor of international human rights law and international humanitarian law in Leiden, as well as a honorary professor at the University of Glasgow. She, before that, filled various different roles. Among them, she served as the director, or the legal director of the NGO Interrights, worked as counsel for Human Rights Watch, spent some time in Guatemala working for an NGO there that engaged in rights protection, and also worked as a legal officer at the International Criminal Tribunal for the former Yugoslavia. So she's got a really long and varied career in human rights and protecting human rights, and is therefore a brilliant person to speak about today's theme, which is strategic human rights litigation, understanding and maximizing impact. And this is her book that she's written, or that was published, what, two and a half years ago now, and which is a brilliant read. I can thoroughly recommend it, and I was very pleased to have the chance, as the first book on the reading list during my research leave beginning of this year, to actually engage with it and now have a conversation about it with you. And I should say that it struck me in many different ways, and I really hope that we together will have a good conversation about it. I have prepared a few questions for Helen at first, and then I'll invite the audience to join us in this conversation, either by submitting questions that you have via the chat function. If you use the chat function, please direct your message with a question to Pia Husch, who is raising her hand there, because she has kindly agreed on curating the questions. Or the other possibility is that you simply raise your hand in the Zoom function, and then have the chance to ask your question directly to Helen, because overall we want to keep it as interactive and sort of open as we possibly can. So with that, let me delve right into this conversation. And I should perhaps start by saying, apart from that I've enjoyed reading the book, that I was struck in many different ways by this book. One may be, from my perspective as a lawyer and as a scholar. Some of you might not know that I've worked for a long time as a legal practitioner only, and in that function dealt with a lot of cases that straddled the boundaries between criminal law and human rights law. And in that regard, in the way maybe how we have sort of seen a change in thinking about the role of lawyers in protecting the law, in being much more than simply those representing interests of clients in many different ways. But this is one of those dimensions I'd like to touch on, but also really, and that's more the scholarly perspective here, how the actors, the lawyers in the room take on a different role in enforcing the law and trying to feed into much broader agendas. But with that, perhaps let me ask you, Helen, how did this book actually come about? What was your motivation to write this book?
Thanks very much, Annie. Hello, everyone. First of all, thank you so much for giving me the opportunity to be here with you today and to have this conversation. I'm a little bit nostalgic. I am indeed a Glasgow girl, I have to say, as Annie has quite rightly said. I'm a little nostalgic because it was exactly 1 year ago was the last time I was in Glasgow, of course, and was due to speak to you then. And that had to be postponed due to industrial action, and we postponed for a month or two. Little did we know, but it's great that we finally get to do that, even if unfortunately I can't be there with you in person. I do have this picture of the cloisters right behind me here that I'm trying to imagine that I'm wandering through these beautiful cloisters, and I've been doing that, looking at it all day, getting into the zone. But it's lovely to be here. How did the book come about? You asked, Annie, and what was the motivation? I think the one-word answer is it came about slowly, as books tend to do. It was actually written quite quickly, but the idea of it germinated over a very long period of time. And it was motivated partly because, as you've said, for many years I've been doing human rights litigation myself in different contexts that you've mentioned already. And in a sense, it grew from a conversation that I was having with myself and with others similarly engaged in terms of what difference this work really made. And it did strike me at a certain point, quite a long time ago, that we didn't really know, actually, that in many ways we kind of assumed the value of litigation. We assumed the importance of taking injustice to courts to look for a solution. And that somehow we weren't really meaningfully engaging in an exploration of what difference does it really make and for whom. So what are the levels of change that litigation can contribute to? And I just felt it was very difficult to be a responsible lawyer if we didn't really know what impact our work was having. I also have to say that conversation has changed over time. You know, this is now a much more active conversation. There's a lot more people focusing on these questions. There's a lot more people doing strategic human rights litigation. And therefore, I think it became more, over time, it became more important to write this book for me, to really inquire into what difference does litigation make, in what kind of circumstances does it make that difference? Can we identify certain factors? And then ultimately, what can we learn from that in terms of litigating more effectively and more strategically? So partly I wanted to understand better the impact of my own cases. I wanted to maybe help other people in light of conversations I was having with an increasingly engaged bunch of actors around the world in terms of how they might think about inquiring into the impact of their litigation and devising strategies around that. And maybe just one more thing to say, Annie, before I hand back to you. In terms of what I wasn't doing, and maybe this is a little bit defensive, but I feel the need to say it at the beginning. As someone who's done human rights litigation, and I do that for a living, and then you write a book on strategic human rights litigation, I do want to say that my function was very much not to promote human rights litigation. So, you know, I don't see myself as that kind of second-hand car salesperson that's shining up this product and suggesting to the world, look, it can do all these things. It has all of these functions. I think it's true that it can, as I've said in the book, and as we'll discuss, it can have many different levels of impact. But I also think the reality is that we shouldn't assume the value of it, that very often it's not a useful tool. Very often it's counterproductive. Very often there are different tools that will be much more appropriate. You know, litigation is often slow, it's often costly, it's often elitist, and very disconnected from the people at the heart of the cases. So it's an important tool, but one that we need to use with caution.
Yeah, thank you. I really like this last point about being cautious and perhaps not overestimating what a case in a court of law can do or achieve, and having to understand sort of the struggle for human rights is a much bigger thing than just litigation in court is certainly true. What interests me, though, when I just go back to the title of this book, Strategic Human Rights Litigation, I'm really interested why you called it that. Others refer to public interest litigation as a notion that has emerged in this increased level of the use of law to further specific agendas, interests, human rights protection in this case. And public interest litigation, sometimes used as or defined as the use of law to advance human rights and equality or raise issues of broad public concern. So why for you strategic human rights litigation instead of public interest litigation, and what's the difference for you?
To be honest, Annie, I don't think there is an awful lot of difference. I'm sorry if that's not as exciting an answer as you would like. But I think it's an important question, because I think it's important to look at what is it that we're looking at here. And I think there's different terminology that's used in different contexts and by different actors, but I don't think it's generally all that significant. Certainly the definition that you've given of public interest litigation aligns very closely with what I would think of as strategic human rights litigation. So sometimes people talk about impact litigation, which is very much what I'm looking at in my inquiry, looking at impact and understanding and enhancing impact. Very often public interest litigation is the term that's used, particularly on the national level, I think. And sometimes increasingly, I think we've got a body of actors that talk about doing strategic human rights litigation. I think the essence is the same, right? Which is it's the use of litigation in a way that pursues goals or concerns interests that go beyond just the confines of the case. So, you know, that affect the human rights landscape in some positive way, that goes beyond just the parties to the litigation, but that has a broader positive human rights impact, let's say. So I don't think, I'm sorry, I can't, I think I do like the term strategic human rights litigation, but I won't give you a long answer on why. I think very briefly, perhaps, I think it's important to focus on the term strategy and strategic, and I think litigation, we can be strategic in our choice to use litigation as a tool, but we can also be strategic in the way that we do that. So in what way do we engage with the litigation so that it can have a broader human rights impact beyond the confines of the proceedings themselves?
Yeah, that's good. I mean, I actually think it aligns quite well, or maybe I would see it as a slightly sort of more focused way of describing what you're doing in terms of efforts of human rights protection, whereas public interest litigation, for me, when I look around me and see all those different efforts that are being made in various areas of law, for example, with regard to environmental protection, enforcement of those standards, public interest litigation might be a good overarching way of capturing it. But that is a discussion probably to be had or continued at another time, when we also should be looking as scholars to find out, or lawyers in general, where are the parallels here in terms of how you choose the cases, and what are the outcomes, what is the impact that you hope to achieve, which then actually brings me to the next point, and that is exactly this notion of impact that you discuss in your book with the subtitle Understanding and Maximizing Impact. In my view, this is certainly one of the key contributions that you make to the debate by investigating this concept of impact of litigation through this lens of various case studies. And these are all, as far as I've understood it, taken from the wealth of your own experience as a lawyer. And therefore, I would like to invite you to perhaps explain a bit, what are the key features of impact, of this concept of impact for you when assessing human rights litigation?
Thanks, Annie. Well, certainly you're right. I mean, this is really the heart of the book. It's really the heart of what it was all about, was trying to understand impact and to set down some kind of framework that might also be useful for other people in terms of identifying the type of impact that human rights litigation can contribute to. Maybe to answer your question on features, because of course the point of the book in a sense is that there are so many different types of impact, and you know, many of them are identified in the book. But what I try to suggest is kind of a way of looking at and a way of understanding impact. And maybe to answer your question on the key features, I would go back to the metaphor of the camera that I used, if you remember, in the book. I'm not testing you, Annie, you don't need to say if you remember or not, but I use a metaphor that I hope will work in terms of looking at and understanding the impact that litigation can have. And the metaphor of the camera is that essentially I've suggested that we have to go beyond the very kind of narrow frame in which we sometimes view litigation outcomes, right? So we sometimes focus unduly on a moment. So we often judgment day, you know, who won, who lost. People talk about that as the outcome of the case, but of course the truth is much more nuanced. So we have to move beyond this kind of snapshot or static image to view impact in a number of different ways. So I suggested, I think, 3 new lenses or 3 new camera functions to look at that. So one of them is, I think, we have to think about impact. We have to view impact through a sort of time-lapse function, right? We have to look at impact over time, not a static moment, but rather a process. So very much this idea of litigation as process, and what is the impact of litigation through that process. So I think that starts, you know, way before you even bring litigation. You can look at the impact of what we might call the shadow or the spectre of litigation, the threat of litigation. That can itself, you know, generate some kind of impact. It can change the discussion, it can change the landscape in some kind of way. And then, of course, in the presentation of arguments through litigation, during the proceedings, and what goes on around the proceedings, judgment is a very important part of that process, but it's just one part of that process. And then, of course, implementation, when we're talking about cases that are dealing with structural injustice, for example, your process of implementation goes on for many, many years, and you know, may indeed be intergenerational. We may be talking about generational change rather than a straightforward implementation of a judgment. So I think we have to look at that whole process of preparing a case, presenting a case, judgment, implementation, and the conversation around it. So litigation as a dynamic process. I think the second thing was to have a wide-angle lens. I suggested our second lens was to look in a broad frame at this. So not just to look at a piece of litigation in isolation, but rather to look at, for example, the processes of repeated cases. So litigation very often has an impact when it's a series of cases brought over a sometimes quite prolonged period of time. Litigation impact, as you've already alluded to, Annie, in one of your comments, I think litigation impact is very often best appreciated in terms of its dynamic with other processes. So litigation as a catalyst to a conversation, litigation as a catalyst to law reform, for example. So looking at how litigation interacts with other processes. So seeing litigation in the context, from which it emerges and in the context of these other processes, whether it be protest or advocacy or law reform or education, or any of the other ways in which human rights actors try to bring about change. And then the third of the lenses that I've suggested that I think is one of the key features of litigation. And this lens is what I've called the high definition lens, right? That enables us to see in our picture, our impact picture, not just what's in the center of it, but to really look behind and to look at multi-dimensions, the sort of multi-dimensional nature of litigation impact. And I think that's very important, partly because this enables us to see impact that's maybe disguised at first. So not what immediately jumps out, not what people necessarily talk about as being the outcome of the case, but something that may go under the radar and may somehow be in the background. And on these levels of impact, I set them out in the book. I won't go through all of them because I think there were 8 or so, and they all had subcategories. But I think we need to look at how litigation brings about legal change, which is, I think, very interesting in the human rights field. Essentially, human rights law is in very large part developed through litigation. It's through bringing these cases that we develop the jurisprudence and that we give content to human rights law. So legal change through the processes, through litigation, we of course can prompt law reform, bring about legislative change. We may very well seek to and can influence practices and policies. That would be a key goal of human rights litigation. There may, of course, be impact in terms of institutional impact. I talk about in the book, the development of institutions that may be necessary to prevent recurrence, for example. We can also, I think about impact in terms of the impact on the conversation around human rights, the quality of the human rights conversation. Does human rights litigation influence that in a positive way? Does it bring new information to light? Does it, perhaps, I think one of the broadest categories is, does it contribute in a sense to strengthening our democracy and strengthening the rule of law by bringing these cases and by the way that we litigate? So I think we have to look for all these different dimensions of impact. And one very important one of them, of course, is negative impact. So we don't only look for the positive impact. That might be what we want to see in our picture. But what may lie behind, of course, depending on who you're talking to, whose perspective we take into account, maybe many different levels of negative impact as well.
Yeah. Well, brilliant how you've taken us through all those different notions. And I think the metaphor of a camera works really quite well. And let me take this to then actually zoom in on one specific part of the impact that you've mentioned, and in this broader conception of litigation as a process. And as some of you may know, international criminal law is one of my research areas, and should I say passions? And there is an interesting overlap, or where I set up and scribbled loads of notes in particular, was on where you talk more about or develop more on the function of information, truth, and historical record, and on sort of the shaping narratives, perhaps, of specific conflicts, for example. And obviously the historical record is one that reverberates with those aims in often cited in international criminal law, although international criminal law obviously needs to have much more of those discussions on what it actually tries to do and to serve for. But I was really quite touched by a fairly small remark there in your book when you mention cases in Palestine, and maybe you'd like to explain there a little bit more, and how you quoted a person that either you interviewed or you somehow engaged with, who saw litigation regarding Palestine as the great library of the occupation, which sort of I thought is a very evocative notion. And that then made me think more about universal jurisdiction cases, which are at the heart of what I am trying to develop at the moment in my research, or take my research into universal jurisdiction cases in domestic courtrooms, where domestic states aim to provide accountability or prosecute cases that aren't linked to their territory, that aren't linked to any of their nationals. And quite fitting perhaps today is that just today a court in Germany reached its first trial judgment, that sort of decided over prosecution of Syrian state-sponsored torture. And there, activists, NGOs try to help shape the narrative, for example, through podcasts. Branch 251 is a podcast I really like listening to because it updates me on the trial proceedings when I can't be there to observe them. And it discusses in English and in Arabic, which I thought is interesting, very new, and provides a window into those proceedings that otherwise doesn't exist. And this then brings me back to your sort of understanding of litigation as processes that aim to shape aim to provide information and to shape perhaps also narratives. What about the accessibility of judicial proceedings? How do we need to think about strategic litigation to ensure public availability of information on cases? And how can we as lawyers contribute in this context? Because I think communication is really one of those hurdles that we might be looking at the moment.
Brilliant. Thank you, Annie. I mean, I completely agree with you that this is really a key issue. It's going to be, I think, more and more important. I mean, people say we live in a post-truth world, don't we? And I think the role that litigation can play in giving us access to greater information and kind of, putting out into the world a fuller truth, and to allowing people, particularly victims and those most affected, to shape that narrative and shape the historical record, I think is crucially important. So I think it's something that is a little underexplored. It's great that you're looking at it in the criminal context. I think we all need to think about it a little bit more. I mean, it certainly seems to me from my experience that there's lots of different ways in which litigation can contribute to that fuller truth. And I think that as lawyers, we can think about the contribution that we make to that, as well as academics and others. I think that the way that we present arguments, the way that we tell the stories inside the proceedings is important. I think the way that judgments are framed is really important. The way that judgments are delivered. We could think of the ICC example in the Onman trial of actually identifying the individual victims as part of that process of rendering judgment. It was very powerful in your field, Annie, in the international criminal field. We can also think of it in terms of remedies, the remedies that we ask for. And this is something where we see a lot of developments. And some of the systems I've worked on in, like the Inter-American system, of course, is famous for having a very progressive approach to remedies. And that really helps when it comes to this question of historical record and a fuller truth. So one example from my own experience that's in the book is the Plan de Sanchez case in the Inter-American system, where one of the part of the reparations was to establish a chapel, for example, that identified the names of the deceased in the massacre, the Plan de Sanchez massacre, to disseminate the judgment, for example, in languages, and to engage in a kind of much broader process of recognizing what had happened and dealing with it in a full sense of reparation. So I think in the way that we frame our requests through the courts themselves and our requests for remedies, in the way that judgments are written, I think we should really look at the role of judgments in historical record and what that means for the way judgments are written. But again, I think to give an example, and one of the things I look at is that I work a lot in rendition and torture litigation, and brought a few cases to the European Court on behalf of Guantanamo detainee torture victim Abu Zubaydah. And those judgments from the European Court are really long, detailed judgments. And they put beyond plausible deniability the role of Poland and Lithuania, which were the states that those cases were brought against. But that's partly because of the way the judgment is framed and the terms in which it's framed. Other judgments that wouldn't necessarily have the same impact on the narrative or on this library, the development of this library and historical record. But also finally, I think, Annie, your point about communication beyond the court is absolutely crucial, and we all need to get better at that. And that's why, again, we need to look at how lawyers and how litigation processes interact with other processes. We need to be able to tell these stories in a different way. I think the role of storytelling and conveying these incredible stories that lie behind these cases and conveying that to a broader audience. We need to write those songs, we need to make those movies and documentaries, and that's, I think, crucial. And also the access to justice. Your podcast example is a wonderful example. And when you were saying that, Annie, I was remembering that one of the case studies I look at is actually the impunity or accountability litigation in Argentina. And I think that the 1980s version of your podcast of now was this gazette that was put out every day during the junta's trial in Argentina. They put out a little newspaper, and it had a huge impact on the conversation and on the extent to which those processes really affected ordinary people's lives, and they affected the conversation and helped to contribute to social change at the end of the day.
Gosh, yeah, that is interesting, Helen. We need to sort of capture this part of the conversation and continue that, because I think finding those ways of communicating what is happening and making it accessible is really, really important, to also link it to the broader political or societal movements that might be there. Now, I'm a bit sort of conscious of the time that we are looking at. So maybe I'll just ask you one more question right now before opening up to the floor, because we've got so many participants who probably have very, very smart questions to ask too. So one last thing, you did mention the negative impact that strategic human rights litigation can have. Can you provide any examples for where you thought in the end it saw a negative impact?
Yeah, unfortunately I can. Yeah, I mean, I think negative impact is everywhere actually in this inquiry, and even in contexts of cases which we might say that they were predominantly positive, perhaps, if we can make that assessment. There've also been limitations in that impact, or a negative impact on one level, but maybe a positive impact on another. Maybe negative impact in the short term, but a more positive impact in the longer term. So maybe you lost the case, maybe that was hugely disappointing for the victims at the center of the case, but maybe ultimately it helped to contribute to a broader or a fuller, more meaningful debate, for example. But I would say, as examples, I mean, I think the story of human rights litigation is really just replete with examples of individuals who've brought these cases and who've suffered really the most atrocious and dire consequences for them personally as a result of doing that. I mean, people who've been killed, who've been raped, tortured, castrated. I mean, there are examples in the book of, I think, just the incredible bravery that people have shown and the determination that really speaks volumes, how much people believe in these processes of litigation, that they're willing sometimes to assume really terrible risks. Of course, it also speaks to the importance of greater protection for victims and for human rights defenders than we currently provide in our international system. But for individuals, I think we see very direct consequences. We also see people being stigmatized and vilified. You know, we see examples of people being prosecuted even for defending people or for themselves, bringing cases that are deemed to be anti-state. We see a growth in anti-state laws around the world, excessive approaches to terrorism legislation, for example. So lots of different consequences for individuals. And then I think more broadly, every level of impact that I mentioned very quickly has a flip side. So we can see positive developments in the law as the law develops through human rights litigation, but of course it can also develop in a negative direction. You can get restrictive approaches to the interpretation of the law. We see bad law makes bad cases. There's lots of examples of that in human rights law as well. You know, likewise, there could be a backlash, and you know, we've seen, I think, examples where there's been a backlash against individuals, against issues, against systems. In fact, we could think of even in the European context, some of the backlash against the European Court of Human Rights, the criticism of judges on the national level, and the pressure that's put on judges when they reach very significant, sometimes, human rights decisions. So I think every level, I think both, you know, socially, politically, legally, we can see levels of potential negative impact that we need to take into account in making responsible decisions. Maybe just one final one that I thought was very interesting when I was exploring this and writing the book, and that's this question of legitimation. So, you know, this question of, you know, in contexts in which so little can really be achieved through litigation, either because the law is so inherently problematic or because there's so much systemic injustice, because there's so much discrimination within the courts, because your courts aren't independent, or for whatever reason, there are real limitations. There's a real risk, I think, many advocates would say there's a risk of legitimation by bringing these cases and creating an appearance of justice, that something is being done. In Palestine, you referred to earlier, that would perhaps be an example, some of the cases in Israeli courts. A number of lawyers in that context have expressed very deep concern that their role in this litigation is creating an impression that there is a level of justice there that there simply isn't. The Guantanamo litigation on Habeas is another example. A lot of interesting writing on this from apartheid South Africa, where lawyers talk about feeling tainted by bringing these cases where they knew that you couldn't really achieve change through the courts. So we do have to be careful. I think we have to take into account that we can create an appearance of justice, but not perhaps really be able to secure change through the courts. And that has to be taken into account in not only the decision whether to litigate, but how we communicate about injustice and about the failures of courts.
Good, thank you. So much in there to think about, but before I get carried away, let me open the floor and invite the audience to ask your questions. Pia, are there any questions in the chat function that you would like to bring in at first, or?
Yes, first of all, thank you, Anni. Thank you, Helen, for the great conversation so far, and also very much enjoyed the parallels to international criminal law and so on. We actually have a range of questions. The first one I was asked was, why did you use the term strategic human rights litigation? What do you think is strategic here? And maybe I'd read it in a way that maybe you can expand a bit on how cases that go to court are actually selected and what the process is here.
Okay. Yeah. So I think lots of things are strategic. I think it can be about the selection of cases, but as I think I mentioned earlier, it can also be about the way that you do your cases, and I think that's important. So, for example, you know, strategic partnerships are important given the conversation we've already had. So the importance of not just doing litigation in isolation, but rather working, you know, as part of social movements or working alongside social movements and advocates and legislatures, working with the media, for example. All of these, I think, are crucial aspects of litigating strategically, because they might enable you to achieve some of the impact that we've spoken about. So I think it's partly about how you do the litigation within the litigation, but more than that, perhaps it's about how you communicate that and work with others beyond the litigation. In terms of the selection of cases, you know, I think it's an interesting question. I mean, one of the ways that I started doing all this, Annie was asking about motivation. I remember when I was the legal director of Interrights way back, and we had case selection criteria, you know, and we had to start thinking about which cases would we take on and which cases would we not. So sometimes organizations have to do that in order to make their own choices about where to put their resources. But we also have to remember that the reality is that cases happen, you know, and that there's a bit of a myth here that somehow strategic litigation is about lawyers. I use the example in the book, I think, of sitting around a boardroom with a blank sheet of paper and mapping out, let's find some strategic cases and we'll go and make this happen and achieve X, Y, and Z levels of impact. And in reality, very often that's not how it happens, and there's a limit to how much you really control. You know, people are victimized and they want to bring their cases, and they have a right to do that. And part of what we're doing here, of course, is giving people a remedy, giving people a voice, and enabling them to empower themselves, hopefully, through the litigation process. But we can still, I think, work in partnership with others. And of course, if the people in the centre of the case are happy with this, and if this is what they want to do, we can still work with others in order to try to ensure that it has a broader impact. But it's not sitting down kind of coming up with cases in a very abstract way, plucking them from nothing and making them happen. At least that's not usually how these things happen.
Great. Javier Solana has raised his hand for a while. Javier, do you want to come in at this point?
Yes, thank you, Annie, and thank you, Helen. Sorry to have missed you in Glasgow, but it's great to see you virtually at least. So actually I had a question that is, if not related, it kind of follows up from the one that you've just been asked, because I found interesting that you talked about your motivation to write the book as an attempt to understand the impact that your litigation was having. So it seems to me that it was an ex-post reflection on what it had been like to litigate. And I wonder if, I find interesting, I'm actually working on this in a research project at the moment on understanding impact ex ante. So I was wondering maybe if you could speak a little bit about how you as a lawyer actually strategize, and I think that's why maybe you have addressed that in your question, in the previous question, and if so, feel free to skip it. But then I'll make a related question, which is, you know, Annie was talking about communication. You talked about communication, the media, collaborating with the legislative power, and it seems to me that based on the 8 levels of impact that you outline on the book, which are very helpful conceptually, one thing that they suggest to me is that it may be pretty obvious, but it's social change, I guess, that these strategic human rights litigation cases are aiming to achieve is so complex that one would imagine that lawyers might want to work closely with other disciplines like psychologists, economists, social scientists more generally. So I was wondering if perhaps in your experience you have had any cases where you did indeed collaborate with people from other disciplines, whether you find that whether you found that useful or not, or whether you think it could be useful for lawyers to begin to work more closely with these disciplines, because at least as I understand it, I'm looking at this more from an environmental litigation and climate litigation perspective. There is huge room for these collaborations, and indeed these can shape the very strategy of the case in terms of the remedies that you ask for, in terms of the cases, if you can choose, that you end up filing. So I'd be keen to hear your thoughts on that from a personal experience rather than an academic experience.
Brilliant, thank you, Javier. That's excellent. Yeah, so maybe on the first part, I mean, I think, I'm not sure if I was clear on that. I think partly I wanted to go back to people that I'd represented and to the partners I'd worked with and to get their perspective, because it does seem to me that we should all do that routinely. And it's a little bit shocking actually that we don't have that built into how we litigate, going back and getting their sense of the impact on them, so that we could do it differently in the future in terms of learning from that. But of course, a lot of it is about setting down a framework that can be useful for the future, so both for myself and for others, right? So what kind of levels of impact might there be, positive and negative, so that we can try to anticipate as far as possible, and then to shape our responses, and of course take measures of protection, but also other measures to try to avoid some of the negative impacts. So it's very much about setting down, in light of my own experience, of course, principally, but also conversations with others over many years, a framework that could be used and that would hopefully be useful for others, even though it's very much not exhaustive, and others will have different approaches to that. It's true, I think I agree with you very much that it's incredibly complex, the sort of social change that much human rights litigation pursues, right? Ultimately, you know, you're talking about just dealing very often with deep-rooted inequalities and injustice, and it's so incredibly complex that, in a sense, I think trying to map out a strategy to deal with that can sometimes be overambitious. But I think it is important to have a kind of holistic view where you at least understand this terrain. You try to develop realizable goals, you know, perhaps short-term goals, medium and longer term. And then I think another crucial thing, and this is, I think, part of any strategy, it's something I emphasize a lot in my work all the time and in the book, is the need for flexibility, the need to be realistic. You can't map out, you know, an A to Z of combating injustice and dealing with the problem of slavery, for example, one of the issues that I was looking at in the book. But you can certainly take a holistic view and try to see how you can move things forward in some kind of way, and how litigation can contribute to movements that are more likely to bring about effective change in some kind of way. But I completely agree with you on the need for an interdisciplinary approach to this. Again, sometimes I think about my own experience and I think, well, we also have to be realistic about the reality of how human rights litigation unfolds. And, you know, I think of the context in which some of these cases have been done, you know, on a shoestring, sometimes a shoestring that you had to find yourself before, you know, I mean, so there is, that doesn't mean that what you're saying is unrealistic, and it's indeed absolutely how we should be litigating. I think we definitely need to litigate in partnership with, you know, all of the people and roles that you mentioned. It's crucial to, you know, have psychologists and sociologists on board in order to really understand the harm. I think in order to understand the nature of violations, you need to be listening to people's own stories, but in some cases you need to be really understanding that so that you can pursue reparation and remedies that are going to bring about lasting change. So crucial to understanding harm, crucial to pursuing remedies. I think, you know, crucial to have a constituency around the case that's engaged from early on, you know, people with a sense of ownership of the case. These are all things that I would think about. I've got to be honest with you, you know, have I ever litigated a perfect case that way? No, I haven't. You know, have there been elements of that in cases? Yes. And have they been really important? Yes, definitely. So when I think about, I think maybe the case that single case I would say had the most impact, I can't say that because they all have different types of impact, but certainly the slavery case that I write about in the book was a case that meant a great deal, I think, on many different levels. And they, you know, working with civil society actors, and, you know, they in turn working with international networks, working with local networks, with support networks for the people to be able to liberate themselves from slavery, working, you know, to some extent with psychological and sociological support and socioeconomic support for the individuals. those things were completely crucial, as well as the media, the communication of the importance of the case through the media. So yeah, we need to be more interdisciplinary in our approach to litigation and to legal education, of course, in the way that we prepare ourselves for that.
Thank you, Helen. That was great to hear. So much information there about your own experience as well. That's great. We have one more question in the chat that asks about the types of impact that you talked about, and how that the kinds of impact are influenced by modern media and the access to it, and how these effects are then influenced, especially with the example of an uncontrolled storytelling, during which actually much can be lost in translation, or the storytelling can really unfold and spread information differently, and you can't control that. How do you feel modern media, social media, change the impact of the three types of impact you discussed earlier?
Yeah, that's an interesting thing to reflect on. I mean, I think, of course, whenever we're looking at social or political impact, but looking at that kind of broad levels of impact, and communication being so central to that, then of course, I think social media and these, I think the inability to control the narrative has to be recognised. I think that the fact is that we have to recognise, first of all, what's hugely beneficial, of course, about that, which is that you can now get these stories out, and you can therefore use, you know, not only social media, but there's so much more at our disposal in terms of tools in order to be able to ensure that experience in one case, a positive development, can be used by others, right? So we have that ability to share experience. And I think social media can be a great tool in that. You know, I think it's true that it's increasingly difficult, of course, to get the sort of stories and the sort of journalistic attention that we want to litigation, because, you know, litigation is a certain kind of story. Courts are seen to be very far removed from ordinary people. You need a certain kind of journalist who's going to be interested enough in that story and to really be able to invest in it, especially when you're talking about the reality that this litigation can go on for decades sometimes, very long processes. You need really invested people who are willing to really work with that and make that a story that can reach people, including, you know, bringing about the sort of social and political change we talked about. And that can be increasingly difficult, I think. I think in general, I think with media under pressure, we have, I think that's increasingly difficult and remains very important. But I think you can't entirely control the story. I'm not quite sure how to respond to that. I think that you can use the tools of social media. You can try to ensure that the right people are having the opportunity to get their story out, that litigation is drawing attention to their story, that you're enabling people to themselves tell their story as a result of the attention that's drawn to litigation. But you certainly can't entirely control what happens with that thereafter.
Thank you. Now let me bring in Gus here at this point, who's one among two who's... Yeah.
Sorry, thank you, Annie. Sorry, I lost audio for a moment. Thank you, Annie, for bringing me in, and also thank you, Helen, for the discussion so far. I just want to come back to sort of one of the early questions on terminology, and I don't mean to be entering into too much semantics regarding strategic litigation versus public interest litigation and so forth. But it seems to me that there is, there's real value in the term strategic, and it reminds me also that we focus very much when we have these discussions on environments that's conducive to successful strategic litigation. But there are also environments where strategic litigation is useful, even if the case itself has a very low prospect of success. So there's examples, John Dugard, for example, in the South African context, there was this pass system where non-white people were required to carry passes with them that they had to show to have permission to be in specific parts of the country without getting into too much detail. in specific points of time. And if you didn't have a pass that allowed you to be in a place, you would be prosecuted. And there was a whole prosecutorial system set up for these kind of prosecutions that resulted in a trial that would last about 40 seconds, and where there was a right to legal representation, but as a matter of course, there was no legal representation. And Dugard instituted and this sort of process where he would provide through CILS, the Center for Applied Legal Studies, representation to a lot of people in these trials. And all of a sudden, a 40-second trial becomes a 40-minute trial, and they bring the entire system to a standstill through this sort of concept of a losing case. But it's very much strategic human rights litigation without litigating a human rights issue, right? So this is just an example of the point I'm trying to make, that that I think that we've somehow lost focus of these environments that's not conducive to what we regard in the normal discussion as human rights litigation, but where we can really strategize litigation in a way to have a real, coming back to the term we've discussed a lot now, but a real impact on the way a system functions. So my point is more a comment than a question, I guess, but it would be very valuable to get some reflection on that. So thank you very much.
Brilliant. No, thank you, Gus. That's a fantastic reflection, and I agree with you very, very fully. I think there are two things. I think that it's undoubtedly the case, if we're looking at that examples of where litigation has had great levels of impact, where you can really see how litigation, like in the Argentina example, for example, after the transition to democracy, you see an environment there that was really conducive. Litigation took full advantage of that, and it helped, and of course that environment, and I've looked in the book at that close relationship between the political and social environment and the legal environment. But it's very often in those other environments that you're talking about, like in Argentina during dictatorship, or in South Africa during apartheid, or in many parts of the world today, where you don't have political and social movements, perhaps, or they're so suppressed, or you don't have the real opportunity to use the courts in an obvious way to bring about justice in a very directly, let's say. It's in those environments that it can often be most important, I think. Even though litigation may not be obviously as successful, it can be really important to work within those environments. So I do talk about that in the book, actually. I talk about the reality that sometimes you're just nibbling at the edges of injustice, and I think that that's sometimes all you can do. You can't necessarily in those environments have as much impact as you would like to have, but you can certainly still have an impact. And one of those impacts is you can expose the injustice, right? By bringing those cases, you can hold a mirror, as one of the Palestinians said, and you can hold a mirror to the problem, you can hold a mirror to the fact that the courts are not providing a functioning in the way that we can. So I agree, in those environments that are not conducive, it can be most important, but it can be perhaps least obviously effective. But it's very often also all people have in those environments. So very important to consider carefully the impact in that context as
well. Right, with that, Friederike, you have been waiting for a while, so please come in now.
Hi, thank you for the very nice conversation and that I can ask a question. I was wondering, because you mentioned so many cases from different jurisdictions, different human rights systems, how does it make a difference in which system the case takes place for strategic litigation? Are some systems better suitable for strategic claims than others? And also I wondered what kind of role does the national jurisdiction or the national courts play in comparison to the international systems?
Yeah, that's a really good question as well, Federica. I think yes, I mean, definitely the system in which you're working will make a difference in lots of different ways in terms of what you can achieve, and also it will need, your strategy will need to reflect the reality of the fora in which you're litigating. So for example, one of the clearest examples I would say is if we think about the difference between the inter-American system and the European system in terms of that approach to reparations and remedies that I mentioned. Because that through the inter-American system, you can end up, like in the Plan de Sanchez case, with these really comprehensive approaches to reparation, where the court will actually order
in a much more directive way than the European Court would ever do, actually order the state to take a whole host of steps, things like the steps to preserve memory that are referred to, but also broader socioeconomic measures to try to bring affected communities back to the position they would have been in but for the violations. So a really holistic approach to reparation. So that is something that of course provides great tools for lawyers, and if you have the opportunity to work in that system, it provides a really important tool that you don't have in the European system, because the European Court will tend to find there is a violation and to have quite a narrow approach to reparation and remedies. The European Court's approach is to leave that for the Committee of Ministers, that then of the Council of Europe, that then oversees the implementation of the judgments. They can engage in terms of some of that detail. There are exceptions, there are cases, but they're rare, where the European Court have been more directive and it's gone beyond just compensation to indicating, for example, that an individual should be released. So remedies and reparation, I think, is one of the big differences. But I think there are lots of differences. I mean, the Niger slavery case that I talk about in the book as one of the cases that I think had significant impact. One of the reasons for that was the system in which the case was brought. So it was brought before the ECOWAS court, that at the time didn't have a lot of human rights cases. So it was a bit of an unknown entity. It was something I was very worried about at the time, but that proved to be an enormously beneficial consideration, because the court resolved the case extremely quickly. The court was taken very seriously, so it depends how seriously your system is taken by the relevant government, and we got quite prompt implementation as well as resolution of that case. So there are many different factors, in terms of loads of factors that would play into how cases or different systems will have different levels of impact. It's very hard to generalize, of course, because it will depend on lots of different things, the nature of the case, the nature of the country, probably, and lots of different factors. And on the national level, I think, strategic litigation certainly arises, of course, both nationally and internationally. In some ways, it's I wouldn't say it's easier, but it's different nationally, because I think you're more naturally, of course, you've got your hearing, you've got your process in the state, you can more naturally engage whole host of different actors and constituents, and it may in a sense be easier to mobilize attention around a case in some examples on the national level. But there are so many different considerations there. I mean, one of them, do you have an independent judiciary? All of the things between systems. Do you have an independent judiciary? Is the judiciary taken seriously? Are the decisions implemented? Will the media, is there a free press that will be able to cover the trial? Is there active civil society? All of these things, of course, will contribute in different systems to strategic litigation and whether it can have the impact. I don't know if that answers your question.
Yes, thanks.
Yeah, we are coming slowly to the end of this session. However, there are two more questions lined up. Maybe we leave Daniela's question in the chat last, because it addresses the big picture. Christian, would you like to come in at this point and ask your question?
Yes, very happy to. And thanks, Helen, for the enlightening conversation, and pleasant as always. My question picks up from Friederike's previous question. I think it's the flip side. I mean, so you've been asked sort of what difference the forum makes. Can I turn this around and ask, I mean, from the way you've described the task, it's clearly more than defending your rights before a court. It's clearly the strategy is there, the signaling effect is there. So much of it is beyond the idea that you'd have sort of reciprocal rights and duties that you take before a court and the court renders a judgment. Which of the forums that you've looked at or appeared at yourself, which is most attuned to that, to those overtones? Which of the courts do you think is best qualified to handle those strategic aspects of the litigation? The fact that it's narrative telling, history writing, ripple effects, rather than delivering justice in an, let's say, on top of delivering justice in an individual case. I'd just be curious to see how you rate the various fora in terms of being up to that pretty daunting task. Thank you.
Yeah, so Christian, you're trying to ensure that I can never appear before any of them again by now, except number one. So I'm quite resistant to answer that question, although it is a good question, of course, because I think there are so many different factors in a sense, right? There are so many, there are some, you know, there are some respects in which I would say the inter-American system is has developed in a way that feels a lot more sensitive to those considerations, but that's mostly about the approach to reparation and the fact that the court itself engages with reparation, for example. So not only does it have a more holistic approach, there's, you know, it accepts that that's fully the function of the court. You can have a separate reparations judgment, you can have a follow-up to reparations court. And whereas, as I said, the European Court has more of a hands-on approach. On the other hand, I suppose there's an extent to which the European Court of Human Rights for All, we have seen recently some real flagrant non-compliance. The court is itself, of course, taken very seriously. So in terms of the way that states engage with that process, that can be very illuminating and important, because states will elaborate, I think, you know, the way that they elaborate their policies, engage with the court, and try to show the court that they are in fact sensitive and responsive to human rights. That can itself, I think, be very beneficial. So I'm not going to give them a 1 to 10, because I hope one day to appear before all of them. I think if the honest short answer would be, I think none of them are really very attuned to it. And I think that's partly why it is important to have these conversations also with courts and bodies, you know, and with governments and others, as to, you know, how can the courts in the way that they carry out their proceedings, how can they be more sensitive to all of these different dimensions? And also, how can we resource them, frankly, in a way that makes that possible? Because there's a huge problem of under-resourcing of human rights courts and tribunals. So, you know, in a sense, I could imagine from within those bodies feeling that piling more and more on those bodies that are struggling to deal with, you know, I think the European Court's currently 62,000 backlog of applications. So I think we need to resource them better, but we also need to look at the way that those proceedings unfold. And I think they all have a lot, there's a lot of change that needs to come about in all of those systems, in the way that the proceedings unfold, in the role that victims have, in the way that judgments are often handed down and dealt with.
Thank you so much. I think we have time for one last question. And this one comes from Daniela, and she's asking, what do you think are the biggest challenges to human rights litigation in a post-COVID world? And she specifically asked about the bigger impact and the role of state actors in the life of citizens, but also the wider gap and the deepening of structural inequalities. Maybe you can comment on that a little bit, a great overarching question.
Gosh, yeah, that is a big one, isn't it? So I mean, I think the challenges that face human rights litigation are very often same as a reflection of the challenges that face human rights more broadly. And we obviously are in a hugely challenging time for human rights. I think that was true before COVID. I think a hugely challenging time for human rights and for the rule of law that's under attack in lots of different contexts. And I think post-COVID, we've worsened the sort of huge problem of inequality that underpins so many human rights violations is vastly worsened, I think, across the globe. So huge, I won't engage in the question of all of the human rights challenges, I think, that are worsened by COVID, but I think we could really look across the board, and we've seen how the health crisis has become a security crisis, become a socio-economic crisis, and all of those things are going to have an impact on human rights litigation. Access to justice, that was already a major problem, is obviously compounded in that kind of context. So I think major challenges for human rights litigation, I think access to justice, you know, to kind of back up a little bit from all our discussion about strategy. The reality is, of course, that most people just have no meaningful access to justice at all, anywhere, nationally or internationally. Internationally, of course, there's still huge gaps in the regional human rights systems. There's no human rights world court, but much more profoundly, people just you know, are disenfranchised to the point that access to justice is a bit of an illusion for so many, for probably the majority of people around the world, in fact. So that's going to be an even bigger problem in a post-COVID world, but it's already a huge problem. And then I think we've got big gaps in human rights litigation in terms of non-state actors. Of course, we've seen huge progress nationally in terms of holding non-state actors to account. A few really interesting cases against Shell in a couple of jurisdictions in the past week. So I think we're seeing important steps forward, but also big gaps in terms of the ability to hold to account non-state actors, including corporate actors. So many gaps. I'm not sure I've answered that question, but I have a feeling I'd be here for about a month if I tried. So were there particular aspects of it that I forgot?
I think this is probably, Helen, as much as one can ask for at this point, where we are actually really only starting to understand what a post-COVID world might look like, let alone reach this post-COVID world first, which I hope from the bottom of my heart happens very quickly. Anyway, but that's a different story. Now I'm conscious of the time. It is nearly 4:15. I think we've had an excellent conversation, and maybe it's a really good note to end on, realizing, yes, there have been steps going forward, but there are so many gaps that remain, and we've seen a lot of sort of areas where I think we need to continue the discussion, whether it is actually how legal education needs to adjust to educate those lawyers and empower those future lawyers to take up those challenges and possibly fill gaps and think creatively how to use the law, whether it is the communication with others, how we place the law in broader society. So there's plenty there to research, to discuss, to teach, to think about, and hopefully this is not the last conversation that we are going to have about this. But with that, let me thank you all, but in particular, Helen, it's been excellent to hear all your thoughts on this, really such a rich conversation that we've had there. So thank you very much, and I do hope that we see you all soon again in future. Bye-bye.
Thanks very much, everyone. Thank you, Annie. Thanks, Christian. Thanks, everyone.
Thank you. Bye-bye.